Jussie Smollett just filed his defense in the lawsuit instituted against him by the, you're making a lot of noise, by the Chicago Police Department to recover the costs of the investigation under the Cost Recovery Ordinance and the False Statement Ordinance. He didn't just file a defense, he also fired a counterclaim for malicious prosecution. You can't make this stuff up. I mean, you could make this stuff up, but some people might have a hard time believing it. Viva Frei Montreal litigator turned YouTuber, and this is now my 8th or 9th video on the Jussie Smollett legal saga. It is proving to be a crash course in Hey guys! Can you stop that noise? I have 3 kids here and 4 nieces and nephews from out of town, so I may have to finish this vlog on the roof. I'll get as much as I can get done indoors. This entire legal saga is turning out to be a crash course in American law. Not going in any particular order, but we have learned through the vlog series on the subject. 1. What is pretrial diversion and how Jussie Smollett had the charges dropped in the first place. 2. That the city of Chicago might be a little corrupt and that the charges might have been dropped as a result of corruption and not necessarily fair application of the pretrial diversion program. 3. That the Osundairo brothers, the individuals who actually carried out the hoax attack on Jussie Smollett at his request and instructions, are suing Jussie Smollett's lawyers for defamation. They are suing Jussie Smollett's lawyers personally for defamation. Video right here. 4. We learned about the city of Chicago's lawsuit against Jussie Smollett civilly to recover the cost of the investigation under the CRO, the Cost Recovery Ordinance, and the FSO, the False Statements Ordinance. I think those are the 4 big ones, but let me just go check my YouTube channel to make sure.
35 seconds later.
Ah yes. 5. We learned about why Jussie Smollett wanted to transfer the file to the federal court system. And 6. Yes, we are up to 2 hands to count all the lessons. I did a video pontificating at what point Jussie Smollett might be beyond redemption or forgiveness for what he has done. Well, if there was any path to redemption remaining, it seems that we might have actually hit the last roadblock. Jussie Smollett just filed a defense to the city of Chicago's lawsuit, but he filed not only a defense, but a counterclaim for malicious prosecution.
Malicious prosecution.
To say that the proverbial bar is high to succeed on a claim for malicious prosecution would probably be something of an understatement. It is notoriously hard to succeed on a claim for malicious prosecution, but before we get there, let's just go through the defense portion of Jussie Smollett's defense and counterclaim. It's actually more interesting from a technical legal perspective than from a substantive one, but let's just walk through the defense before we get into the counterclaim. And oh yes, not only is he counterclaiming for malicious prosecution against the city of Chicago, he is counterclaiming for malicious prosecution against employees, detectives who all had a hand in the investigation of the allegedly false police report for the alleged hoax of a hate crime he had orchestrated and committed against himself. Okay, let's start from the beginning though. As a pure matter of procedure in a defense to a lawsuit, one has to admit or deny the allegations in the initial lawsuit. From what I understand, Quebec has a bit of a different procedural system than the United States. In the US, you either admit or deny the allegations, pure and simple. Under the Quebec civil law system, and I'm fairly certain it's virtually identical throughout the rest of Canada, you can either admit an allegation, deny an allegation, have no knowledge or ignore the allegation, meaning that you have no specific knowledge to either admit or deny the allegation, or you can deny the allegation as drafted and rectify the allegation to specify that which you deny while clarifying that which you might be otherwise prepared to admit had it been drafted differently. Now, as a pure matter of procedure, it is very important to understand that one does have to specifically respond to each and every allegation, lest they be deemed to be true for failure to have been addressed. Now, this may be jurisdictional and depend on the applicable procedure, but typically if one does not respond to an allegation, it can be argued that it was deemed to be admitted. As you will see from the first half of this answer and cross-claim, although we're not going to go through each and every one of the allegations, Jussie Smollett reproduces each and every one of the allegations from the city of Chicago's lawsuit and responds to each and every one of them specifically. Let's just take an example and look at paragraph 7. On the morning of January 25th, 2019, defendant texted Abel asking when Abel would be leaving on his upcoming trip to Nigeria with his 27-year-old brother, Olabinjo Asundairo Ola. Answer. Mr. Smollett admits that he sent a text message to Abel Asundairo on January 25th, 2019, asking when he would be leaving town. Otherwise, Mr. Smollett denies the allegation contained in paragraph 7. What is the purpose of this? It is pure legalese, cover your tushy, admit the portion that is undeniable, and then deny anything else that is inconsistent therewith. And we understand and can predict the tenor of what's going to go on for the rest of this answer to the claim. Jussie Smollett is basically going to admit that which cannot be denied and deny that which is incriminating. And let's just take paragraph 12 for example. After Ola attested to his trustworthiness, defendant and Abel and Ola, the Osundairo brothers, discussed their plan to stage a fake racist and homophobic attack on defendant. Defendant, Jussie Smollett, directed the Osundairo brothers to stage the fake attack on the evening of January 28, 2019, near his apartment building in Streetville. Defendant and the Osundairo brothers agreed that the Osundairo brothers would catch defendant's attention, and the fake attack would begin when the Osundairo brothers called defendant on Empire F, Empire N. Answer, deny. And now in law, we have what are called joined issues. Someone made a statement, someone denies it, you go to trial, you make your evidence, and a judge or jury will determine which statement is true, the affirmation or the denial. At paragraph 19, things start to get interesting because a mere denial is not going to suffice. During the same conversation in which defendant and the Osundaira brothers planned the fake attack, defendant also gave Abel a $3,500 personal check made payable to Abel. The memo line of the check contained the words 5-week nutrition workout program, don't go. And we know that Jussie is not going to be able to deny a certain element of fact in that he did in fact give Abel a check for $3,500. Mr. Smollett admits that he gave Abel Osundaira a $3,500 personal check made payable to Abel with the memo line 5-week nutrition workout program, don't go, for a 5-week personal training and nutrition program in preparation for his music video shoot on February 23rd, 2019, for his song Don't Go, and otherwise denies the allegations in paragraph 19. The issues have been joined. The allegation is that Jussie Smollett gave Abel a check for $3,500 with a certain memo, which was actually not what the check was for, it was for the fake attack. Jussie Smollett admits, I gave him the check, but it was in fact for a training session for my upcoming music video called Don't Go. And it's going to be up to a judge or jury in this case to determine what is in fact the legal reality. And for those of you who are relatively new to the channel and haven't seen previous vlogs where I discuss the difference between real reality and legal reality, a judgment makes legal reality even if it is not in fact real reality. You know what I mean. When a judgment has been rendered, that creates a legal reality even if it does not reflect in reality what actually happened, which may only be known to the powers that be. And just a few more allegations and their response because these are very interesting facts. Paragraph 23. On the evening of January 28, 2019, defendant's flight into Chicago was delayed and he called Abel telling him he needed to delay the staged attack and Abel agreed. Answer. Mr. Smollett admits that his January 28, 2019 flight to Chicago was delayed and that he called Abel to let him know of a delay because they were scheduled to have a personal training session together at 9:30 p.m. Otherwise, Mr. Smollett denies the allegations in paragraph 23. Paragraph 24. Defendant's plane landed at Chicago O'Hare International Airport at 12:30 a.m. on January 29, 2019. Answer. Mr. Smollett admits that his flight to O'Hare landed at approximately 11:45 on January 28, 2019, but he did not disembark the plane until closer to 12:30 a.m. on January 29, 2019. Paragraph 25. Cell phone records indicate that at 12:49 a.m. defendant and Abel spoke by telephone. During this call, defendant told Abel the attack should take place at 2 a.m. at the agreed upon location. Minutes later, Ola ordered an Uber to pick the Osundaira brothers up at their home. Answer. Mr. Smollett admits that Abel Osundaira called him at approximately 12:49 a.m. on January 29, 2019 to reschedule their workout that evening to 9:30 a.m. the following morning. Answering further, Mr. Smollett admits that between leaving New York and arriving to Chicago, Mr. Smollett was active on social media, posting updates regarding his flight delay and arrival status via his Instagram stories and in direct messages with his contacts. Mr. Smollett further admits that Abel called him after learning from social media that Mr. Smollett had finally landed back in Chicago and instructed Mr. Smollett to eat 4 eggs prior to their workout session in the morning, per his nutrition plan. Mr. Smollett denies that he, quote, told Abel the attack should take place at 2 a.m. at the agreed upon location. Mr. Smollett lacks knowledge or information sufficient to admit or deny the remaining allegations in paragraph 25 and therefore denies them. The issues are joined. Plaintiff has made the allegation, defendant has denied them, and it's going to be up to a jury to determine which side is more believable as to what actually occurred. I know what I think, but I'm actually genuinely curious to know what everyone else thinks. Reading these particular allegations and the responses, who believes what is more plausible?
Comment in the comment section below.
Alright, and it goes on, and there's really no point going through each and every one of the allegations. We know the bottom line. Jussie Smollett is denying having filed a false police report. He is denying having paid the Osundaira brothers to do it. He admits that the Osundaira brothers did in fact carry out the attack, but denies having had anything to do with it, pleading that he is in fact the pure victim of this entire ordeal. Let's skip to the affirmative defenses because they are in fact interesting. The city is not entitled to recover further costs for services provided by the city in investigating and responding to Mr. Smollett's police report because it had already collected $10,000 from Mr. Smollett. Having agreed to accept $10,000 from Mr. Smollett as payment in full in connection with the dismissal of the charges against him, the city cannot seek additional recovery from Mr. Smollett under the doctrine of accord and satisfaction. Alright, and this is one of those double-edged swords of an allegation for the following reasons. Jussie Smollett is arguing that there was an agreement with the city. They dropped the charges in exchange for his payment of $10,000. Because they accepted that payment as part of the deal to drop the charges, they cannot now claim the additional charges of the investigation under the cost recovery ordinance or the false statement ordinance. Two problems with that. You may recall from my video on Jussie Smollett's motion to dismiss that the city of Chicago actually filed jurisprudence to the effect that one did not require a guilty condemnation in order to recover costs under the false statement ordinance. So it's not clear in law that even if there were indeed a transaction, that it would preclude the city from recovering costs in virtue of a false statement. The transaction ostensibly relates to the dropping of charges in exchange for the forfeiture of the $10,000 bond that Jussie Smollett put up. In law, I believe it would be a stretch to argue that it was a full and final transaction for any and all claims arising out of the incident. The second problem relates specifically to the cross-claim for malicious prosecution. Jussie Smollett is suing for damages resulting from malicious prosecution of the crime itself, not of the civil proceedings. And in order to succeed on a claim for malicious prosecution, one of the essential elements that needs to be proven is that there was an absence of probable cause to have instituted those proceedings. The other essential element that needs to be proven is malice as the sole or primary purpose for having instituted those proceedings. I see someone in the corner of my eye.
Can we have lunch?
You want to eat food?
It's 1 o'clock.
It's 1 o'clock and you'd like to eat food?
Yes.
I have to suspend this video. I will continue it on the roof. Now. You know what? I can actually finish with the 3 remaining affirmative defenses while the water for the noodles boils before going on the roof to deal with the counterclaim for malicious prosecution. Second affirmative defense, waiver. The city has waived any right to recover further costs for services provided by the city in investigating and responding to Mr. Smollett's police report because it has already accepted $10,000 from Mr. Smollett. Having agreed to accept $10,000 from Mr. Smollett in connection with the dismissal of the charges against him, the city has waived its right to seek additional recovery from Mr. Smollett under the doctrine of waiver. This one is as creative as it is self-explanatory. Third affirmative defense, equitable estoppel under Illinois law. The city is equally estopped from seeking to recover further costs for services provided by the city in investigating and responding to Mr. Smollett's police report. By its conduct and agreement to accept the $10,000 from Mr. Smollett, the city induced Mr. Smollett to his detriment to rely on that conduct as satisfying any amount that Mr. Smollett may be required to pay the city in connection with Mr. Smollett's police report. The city then violated this agreement by bringing a civil claim against Mr. Smollett. Due to this misrepresentation, the city should not be entitled to receive any additional compensation from Mr. Smollett. Hey Siri, what does estoppel mean?
Estoppel means the principle which precludes a person from asserting something contrary to what is implied by a previous action or statement of that person or by a previous pertinent judicial determination.
What she said. And the fourth one is by far the most creative. Fourth affirmative defense, unclean hands under Illinois law. The city is barred from seeking to recover costs for services provided by the city in investigating and responding to Mr. Smollett's police report due to its inequitable conduct in filing criminal charges against Mr. Smollett without probable cause and maliciously prosecuting him in bad faith. That is one heck of an evidentiary burden Jussie Smollett is going to have to overcome to prove. And it leads us perfectly into the counterclaim for malicious prosecution, which we will do on the roof. Cross-claim for malicious prosecution, let's begin. And it's not just that Jussie Smollett is suing the city of Chicago for malicious prosecution. He is also suing, and I'm listing from the lawsuit, CPD Superintendent Eddie Johnson, Detective Commander Edward Wodnicki, Detective Michael Theus, and John and Jane Doe defendants 1 through 10, those being employees of the city who partook in the investigation. And we'll go through some of the key allegations, but in a nutshell, Jussie Smollett is alleging that the city of Chicago and the other defendants maliciously prosecuted Jussie Smollett by ignoring some of the allegedly exculpatory evidence and filing charges where there was patently no reasonable cause to do so. Either Jussie Smollett or his attorneys play chess because there's a good expression in chess that the best defense is a good offense. Unless you are just losing the game, in which case it is no longer an offense, it is just a kamikaze run to the end. And I've got to tell you, in as much as the road to redemption is narrowing, this seems like a kamikaze, Hail Mary, all or nothing, straight to the end, be damned with anything. Okay, sorry.
That's what I think, and what I think is irrelevant.
At paragraphs 13 and following, Jussie Smollett basically just describes the attack as he seems to believe it occurred in his mind. Shortly after 2 a.m. on January 29, 2019, Mr. Smollett was physically attacked by masked men outside his apartment building in the Streeterville neighborhood of Chicago. The men yelled racist, homophobic, and political slurs at Mr. Smollett, poured bleach on him, and hung a noose around his neck. Mr. Smollett only saw the front of his primary attacker, who was wearing a baklava-style mask that covered the entire face except for the area around the eyes and the bridge of the nose, from which Mr. Smollett saw that the attacker was white-skinned. After the attack, Mr. Smollett returned to his apartment and encountered his artistic director, Frank Gatson, who was staying with him at the time. When Mr. Gatson learned that Mr. Smollett had been attacked, he urged Mr. Smollett to call the police. Because Mr. Smollett was reluctant to do so due to privacy concerns, Mr. Gatson called 911 himself. That has been Jussie Smollett's version of events from the very beginning. Incidentally, as my grandmother always used to say, in order to be a good liar, you have to have a good memory. If Jussie Smollett's artistic director, Mr. Gatson, was staying with Jussie Smollett at the time, there may be some stories to reconcile as to whether or not Jussie Smollett in fact scheduled a training session for 9:30 the evening when Mr. Gatson chats and was staying with him. Regardless, there are very capable and intelligent lawyers already in the file who are presumably going to be asking these questions at some point sooner than later. Jussie Smollett then goes on to tell the story that we've heard him say time and time again. Paragraph 17, however, is particularly interesting. When Mr. Smollett told CPD officers that one of the attackers yelled, "This is MAGA country," before running away from the scene of the attack, Mr. Smollett noticed that the CPD officers became visibly uncomfortable. What are they trying to imply there? Jussie Smollett then goes on to allege that because the Osundara brothers initially denied having been the perpetrators of the attack, they are not to be believed when they say that Jussie Smollett in fact paid them to perpetrate the attack. And then he alleges what the attorneys for the Osundara brothers are alleged to have said in the wake of the incident. Paragraph 28. Mrs. Schmidt, the Osundara brothers' attorneys, also said, "It's an awful thing that happened to Jussie, but it's not my guys." She added, "When they first learned what happened to him, they were horrified. This is someone they know. This is someone they've worked with, so they don't want to see somebody go through that." The Osundara brothers, in having denied being the perpetrators, are not to be believed, and therefore the city, in acting on the Osundara brothers' statements, allegedly maliciously prosecuted Jussie Smollett in the absence of any reasonable cause. Up to you to determine whether or not you buy the argument. And in an attempt to further undermine the credibility of the Osundara brothers' statements, Jussie Smollett at paragraph 37 alleges that it was only after the 47th hour, when they were in custody, that they allegedly turned on Jussie Smollett. Indeed, at paragraph 29, it's alleged that the Osundara brothers were only legally allowed to be kept in custody for 48 hours without being charged, and for the first 47 hours they maintained their innocence, and it was only after the 47th hour, after they met with their attorneys, that they allegedly changed their story and turned on Jussie Smollett. Smollett also argues that the Chicago Police Department engaged in a very unorthodox practice, interrogating both brothers in the presence of one another. The theory being that this would allow them to orchestrate their story and testimony against Jussie Smollett. Paragraph 39. On information and belief, the standard protocol directs that different individuals under interrogation for the same crime are questioned and provide statements separately. Paragraph 40. Here, however, although Abel and Ola were under investigation for the same offense, the CPD, including Detective Commander Wodnicki, Detective Theus, and John and Jane Doe defendants, allowed Ola to be present while Abel was being interviewed by CPD officers to make Abel more comfortable, compromising the integrity of the questioning and allowing the Osundara brothers further opportunity to coordinate their fabricated statements. This is the claim for malicious prosecution in a nutshell, that the Osundara brothers conspired together to frame Jussie for the attack that they perpetrated, and that the Chicago Police Department acted maliciously in prosecuting Jussie Smollett by accepting the Osundara brothers' version of events in collaboration with all of the other evidence over the story being promoted by Jussie Smollett. Another interesting allegation at paragraph 82. The text messages obtained by the CPD included one significant text message from Abel to Mr. Smollett sent around noon on January 29th, 2019, about 10 hours after the attack and after news of the attack had been made public, in which Abel wrote, "Bruh, say it ain't true, I'm praying for speedy recovery, SH blank T is wild." 83. It is significant that in none of their statements to police did the Osundara brothers claim that Mr. Smollett told them to send such a text after the attack or otherwise claim that this text was pretextual. This text message directly contradicted the Osundara brothers' statements that the attack was a hoax which Mr. Smollett had orchestrated. The CPD, however, ignored this critical evidence because it undercut the Osundara brothers' hoax narrative. And the underlying irony in all of this is that Jussie Smollett is accusing the Osundara brothers of lying and fabricating self-serving statements while relying on what might otherwise be a lie and a self-serving statement to promote his own innocence. And then in responding to one of the more damning allegations that Jussie Smollett texted one of the Osundara brothers saying, "I need your help on the down low." Paragraph 87. In a text message from Mr. Smollett to Abel on January 25th, 2019, Mr. Smollett asked Abel when he was leaving on his upcoming trip to Nigeria. After Abel responded that he and Ola were leaving for Nigeria on the evening of January 29, 2019, Mr. Smollett texted Abel stating, quote, "Might need your help on the low. You around to meet up and talk face to face." Apparently, the Chicago Police Department took this to mean that Jussie Smollett needed Abel's help on the down low, which I think means for something illegal. And with the testimony of the Osundara brothers, concluded that this was the meeting that they had face to face to orchestrate the fake hoax attack. What is Jussie Smollett's response to this to support a claim for malicious prosecution? Paragraph 89. In fact, however, Mr. Smollett's text message was sent to enlist the help of his personal trainer to obtain herbal steroids in Nigeria to help him lose weight. The internet search history for one of the Osundara brothers obtained by the CPD shows numerous search queries on January 25 and January 27, 2019 for herbal steroids and banned bodybuilding substances. Paragraph 92. That search history from the time period in question, which CPD obtained, demonstrates that not only were the Osundara brothers interested in steroids and steroid alternatives to aid in losing weight and increasing muscle mass, but they were also specifically interested in what substances were banned in the United States 2 days before their trip to Nigeria. Considered in the context of the other text messages regarding macronutrients and projected fat loss, the only reasonable conclusion is that Mr. Smollett's text messages about meeting on the low concerned banned steroids which Abel could obtain for him in Nigeria. The only reasonable conclusion is a big, big statement. And then there's allegations that the CPD ignored other evidence that might have indicated that the Osundara brothers were working in concert with another individual and not at the direction of Jussie Smollett. Count 1, state law claim for malicious prosecution. Count 2, 42 U.S.C. section 1983, claim malicious prosecution, paragraph 151 and following. Following the filing of criminal charges against Mr. Smollett, counterclaim defendant Johnson credited old-fashioned police work for closing the case. Superintendent Johnson then went on a publicity tour in which he appeared on numerous television programs wherein he continued to make knowingly false statements about the evidence in Mr. Smollett's case while touting CPD's fine detective work and condemning Mr. Smollett. Those statements by counterclaim defendant Johnson demonstrate that the city counterclaim defendants sought have proceedings commenced against Mr. Smollett based on information that they knew or should have known to be false and unreliable. What are the criteria for malicious prosecution? Now, this is going to be jurisdictionally dependent, but I'm just going to lead 5 of the generally accepted criteria in order to establish malicious prosecution. 1. The institution or continuation of a civil or criminal legal proceeding against the plaintiff. 2. By or abetted by the defendant, the prosecutor, or the plaintiff in the malicious action. 3. Termination of the prior proceeding in favor of the plaintiff. For instance, the case was dismissed. 4. Absence of probable cause for instituting the prior proceeding. 5. Malice as the primary purpose for the prior action. And 6. Injury or damage to the plaintiff as a result of the prior action. Now, thus far, I have in fact been very accurate on my legal predictions, having recently been vindicated on my prediction of what would happen in the Covington Catholic Kids lawsuit. My prediction, not a snowball's chance in a Canadian winter is this counterclaim going to be granted. The requisite conditions in order to meet the required threshold for malicious prosecution will not be met in this case. This is a situation where Jussie Smollett's entire argument for malicious prosecution against the city and its employees is entirely based on the fact that the city should not have believed the Osundara brothers' version of events over Jussie Smollett's, notwithstanding all of the other evidence that the city obtained. That the city was malicious in disregarding the allegedly exculpatory evidence that Jussie Smollett relies on in his counterclaim to justify his innocence. That the arguably self-serving statements made by the Osundara brothers should be disregarded when they incriminate Jussie Smollett, but should be believed when they allegedly exonerate Jussie Smollett. Jussie Smollett is alleging highly contextualized and creative interpretations of text messages as evidence of the city of Chicago's alleged malicious prosecution. You can come to your own determination. I know that I've come to mine. But at the very least, at least now we've gone through the actual counterclaim itself. Alright, I can feel the dog shivering on my lap, so I'm gonna go inside right now, but you should watch the video where I break down the lawsuit itself against Jussie Smollett. I'll link it right here. And if you haven't already seen it, check out the video where I explain why Jussie Smollett wanted this lawsuit moved to federal court. I'll link it right... No, I gotta link it here. I'll link it right here. And as always, if you like my video and content, please be sure to like, share, subscribe, hit the notification bell, drop a comment in the comment section below. If you want to support the channel, merch links and PayPal link in the comment section below. There's a PayPal link somewhere in the banner of my YouTube channel. And now you know your vlog. Peace out. Booyah!